Some cases become true classics and change the law or even the legal system for centuries afterwards. The Earl of Oxford's case is one of the most colossal cases of all time, but it's very difficult to read, and these days it's almost forgotten. The case was a showdown between two towering figures in the development of English law: Sir Edward Coke, a champion of the common law, and the Lord Chancellor, Sir Thomas Egerton, the champion of equity. Equity law had by 1615 already been around for a century or so, but the Lord Chancellor took it to new levels, sometimes imposing injunctions to prevent common law judgments being carried out. The two court systems and the two legal systems were set for a clash. The case which brought it all to a head arose from a grant of land made to Magdalen College in Cambridge. There were strict statute laws about how universities could dispose of land, but Queen Elizabeth I wanted the college to be able to make a profit, so they devised a scheme where the college sold land to her and she then leased the land out for development. They figured that as the Queen, she was effectively beyond the reach of the statute. The result, some years later, was a conflict between two claimants for the same bit of land. One of them sought and obtained a judgment in the common law, but the other obtained judgment in the courts of equity. One of the two had to prevail. The Lord Chancellor wasn't backing down. He said, "The cause why there is a chancery is for that men's actions are so diverse and infinite that it is impossible to make any general law which may aptly meet with every particular act and not fail in some circumstances. The office of the Chancellor is to correct men's consciences for frauds, breach of trusts, wrongs and oppressions, of what nature soever they be, and to soften and mollify the extremity of the law." In the end, it was necessary for the King himself, by this time King James I, to choose which court would prevail. The King ruled in favour of Chancery, and to this day, while equity follows the law, an equitable judgment will prevail over a judgment of the common law. Without this case, in English and Australian law, we might not have equity law at all.